Hello, I'm Huw Thomas and I'm a partner at Carey Olsen in Jersey. I practice employment law, data privacy, and across a range of other areas that my partners like to call the weird stuff. This is our podcast, People, Behaviour and Governance, which is a podcast about behaviour in the workplace, why people behave in the way that they do, and what employers should do about it. Today, I'm delighted to welcome a guest all the way from London on video conference, Louisa Simpson, who's a barrister at Pump Court Chambers in London. Louisa practices across also a range of areas, including employment law and sports law, and she's the deputy head of their sports law team. Welcome, Louisa.
Thank you for having me.
That's right. And one of the reasons that we've been trying to get Louisa for a while as a guest is that she's got broad experience in things like employment. And whilst offshore jurisdictions like Jersey and Guernsey have their own very specific laws, we do draw on UK law and examples for an awful lot of our employment law. And if you look at the employment Jersey law, the discrimination Jersey law and their Guernsey equivalents, they are very much drawing on UK exemplars. And Jersey is shortly to look at things like whistleblowing, which is, we're told, going to be the next big statutory step for Jersey employment law. The UK have got their very own set of whistleblowing protections. And from the look of the consultation documents that we've seen, again, UK examples are going to be very important to that process. And Louisa has appeared recently in the Court of Appeal in Sullivan and the Isle of Wight Council, which looked at the question of whether whistleblowing protection ought to be extended to job applicants. So I'm sure we'll touch on that as we go. So, Louisa, welcome to the podcast. I understand that Pump Court have also got a podcast that you're involved with, so you shouldn't be a stranger to this process. You've got a really broad practice from employment law to sports law. What kind of got you to those areas of law? What was the interest there?
It does sound really broad, and actually even more so when I say I also do professional regulation and discipline. But actually there's so much area of crossover between those that it doesn't feel so broad. It feels quite specialist, really. It is predominantly employment and discrimination, but everybody that is professionally regulated, or almost everybody, also has certain employment rights, benefits from the same discrimination legislation, and so there's real crossover there. When I'm dealing with an employment client, very often there may well be regulatory issues that appear in the same case in relation to the same clients. And when I deal with sports law, generally for me personally, it's a broad sector, but I deal with it in terms of the employment and discrimination aspects of it, as well as regulating the sport, so bringing the sport into disrepute, and anti-doping violations and things like that.
And what is it about employment law that interests you? What led you to be an employment lawyer as opposed to something?
It for me is the perfect crossover between really dealing with the academic, interesting part of the law, and it's constantly evolving and changing. And I think that there are these really interesting intellectual debates about how the law in employment and discrimination ought to be shaped, but also it's an excellent crossover between that and really being very people-centred, people-focused. We're dealing with probably the most important relationship anybody has outside of their family, is their employment relationship, worker relationship, and so it's something that's really important to everybody, and it's that keeps it all very interesting for me, both in terms of the day-to-day and that human aspect of it, as well as the intellectually stimulating aspect of it.
Yeah, I think that's probably common to most employment lawyers. It's the sort of behavioural aspect of it that's most interesting, and it's you also get an awful lot of law involved as well, including your recent Court of Appeal case. What did that involve?
Yes, we say my Court of Appeal case. I was junior to Fergus McCombie at Chambers. He was representing the council, and I assisted and accompanied him as junior in the Court of Appeal. The case centred around whether or not the whistleblowing protections that we already have in England and Wales ought to be extended, not just to workers and employees and certain other categories, but generally to people who are applicants for a job, which, as it presently stands, though that category of people aren't protected from whistleblowing, detriments of whistleblowing it wouldn't be dismissal, but from being blacklisted and not being offered a job, for example. So the tribunals had decided that the claimant in that case, so Ms. Sullivan, she was an applicant for a job, and that she was trying to suggest that she ought to be protected against whistleblowing detriment in the same way that she would be if she were an employee or a worker. As I say, English law as it stands at the moment says no, and what she argued to the Court of Appeal was that that was a breach of her human rights, because workers and a specific group of applicants, only NHS applicants, are already protected against whistleblowing detriments, and she said that she was in an analogous position to them, so she ought to be protected too. The Court of Appeal, though, said that she wasn't in a relevantly similar position to either of those groups, workers or NHS applicants. She wasn't in any form of employment relationship, and NHS applicants are protected due to a specific report which identified a particular need to resolve urgent problems in the NHS and the health service relating to patient safety. And that didn't apply more broadly to applicants for jobs in all other sectors. In any event, though, as well as not being in the same position as those two groups, the Court of Appeal had held that she that if there was a difference in treatment, which there clearly is between job applicants and workers or NHS applicants, that's objectively justified. So it wasn't a breach of her human rights, Ms. Sullivan's human rights, because the courts have to give substantial weight to the judgment given, or the judgment of Parliament as the elected decision maker. They considered it, they decided not to extend the protection to applicants generally at that stage. And so the Court of Appeal chose not to intervene in that judgment that had already fairly recently been made.
Yeah, so I mean, it's one of the things that comes out of that case for me is the unbelievable complexity when you talk about whistleblowing protection. And it's one of those things. It's very easy to say we should have whistleblowing protection for whistleblowers in the workplace. It's less easy to then transpose that into law. It's one of the issues in a small jurisdiction like Jersey, is that we end up importing some of the downsides in, say, the law in England and Wales if we adopt something similar. And we end up with a very complex piece of law which isn't necessarily well suited for a smaller jurisdiction. If you were a sort of employment law god for a day, is whistleblowing legislation something you'd import from England and Wales, or are you
I think we would definitely be looking at a much more streamlined version of what we do have that perhaps works in a less convoluted way, for sure. I think you asked me when we were preparing for this podcast or discussing what we might talk about, whether the system that we have and the legislation we have protecting whistleblowing at the moment works well. I think, well, it works to an extent, but that's as far as I would go with it. It's not neat. It's not straightforward. It's not without caveats and discrepancies. And I think that comes from the fact it has developed gradually over time. It has been extended and added to over time. It's also been, from the outset, it was sort of slotted into the existing Employment Rights Act with new subsections and amendments, making it already from the outset quite a messy beast, which doesn't quite necessarily fit into the right place. It seems to fit more within the realm of the discrimination legislation that we have and the provisions of the Equality Act, but it's not there. It's under the Employment Rights Act, which protects different employment rights. And so we have that discrepancy already from the beginning, and its scope has already been extended quite substantially by the various subsections within the Employment Rights Act already. So an extension to agency workers, for example, under Section 43K, the extension I've mentioned to NHS applicants under 49B, but also in case law. So there's various cases where the protection against whistleblowing detriment has been extended, where employment has started, but that individual hasn't actually commenced the work. So the contract date has started, but they've not started working. Protection where they've already left employment, where the disclosure was made after termination, or where the detriment occurred after termination, where the disclosure has even been made to a previous employer. None of that is clear from the legislation itself and has had to be it's been drawn out of the case law, which has interpreted the legislation subsequently. So if I were, as you say, sort of employment law god for the day, and I were importing a version of whistleblowing protection, I think I'd be looking at all the different ways in which the legislation that we do have in England and Wales has been interpreted by the courts and extended by the various subsections, and perhaps try to formulate some neater, more streamlined way in which that could be done.
Yeah, because in the end, we all say we want to speak up culture in the workplace, and again, it's one of those really easy things to say, isn't it? That yes, a speak up culture would be fantastic. What that actually means in practice is less clear cut, because for me, you can do one of three things in terms of speech in the workplace. You can mandate it. You can force people to speak up when things go wrong, and suspicious activity reports, things like that, fall into that category. You can encourage speaking up, which is probably a subject for another day, or you can protect it, and it's into that sort of third category that whistleblowing falls. And I get from where you're coming from in relation to the England and Wales approach, is that it's been sort of built on. There's a slight danger that I think in terms of importing that into a small jurisdiction like Jersey, is that we end up importing a lot of case law, a lot of concepts that are perhaps far too complex for what we're trying to achieve. Are there upsides to the England and Wales approach? I mean, does it work well in general?
As I say, it works, and it has been interpreted. And some of those interpretations are things that may seem fairly obvious or straightforward, that it ought to apply in those situations. And I think you're right in saying that actually if all of those things were transported over, you would be transporting the case law. But without that, you're perhaps just transporting the legislation as it is, which still does require that interpretation and proper thinking about where the limits of it do actually lie. So that may be the difficulty. But in general, it does work. It's just, as I say, it's just messy.
Yeah. I mean, the other area where England and Wales protect speech is religious and philosophical belief as a protected characteristic under the Equality Act. Oddly, Jersey doesn't have that as a protected characteristic, and Guernsey does, although I don't think we've had any particular case law in Guernsey just yet on it. I've always been slightly surprised by the fact that Jersey doesn't do that, although, oddly, we've never particularly noticed the fact that we don't have that as a protected characteristic. Do you think the England and Wales approach gets it right with philosophical belief and religious belief?
I think it's one of those areas, again, which is, and perhaps this is all of employment and discrimination law, it's still developing. We are still developing the proper ways in which different parts of those protections are being interpreted, and where their limits are perhaps where they ought to be, or where they are in terms of how the statute has actually been drafted as it stands. And obviously future proposals for change as well, which I think we'll come on to. But it really stems from the European Convention on Human Rights in any event, that's then been transported into our legislation under the Equality Act and elsewhere. So we've got the right to protected beliefs, we've got the right to freedom of speech, to freedom of expression. And it's from the ECHR that we then see the right to have a protected belief, a protected characteristic of religion or belief under the Equality Act, and the right not to be discriminated against because of those beliefs.
Yeah. I think the difficulty, of course, is that you end up with employers effectively having to referee often a political battleground between those with diametrically opposed views. And the big one recently seems to be gender critical belief, which is still rumbling through various tribunals and courts. Are employers in England and Wales any closer to understanding where the line should be drawn in relation to that, or are they still sort of grappling with exactly that sort of very polarised sets of beliefs, which you've got two sets of employees sort of seeking the right to assert?
Yes, I unfortunately don't think that there's very much clarity, or if there is, that it's clear the way in which employers ought to deal with that. I think it's very difficult because they're in a situation where, as you say, they are the ones having to tread the right line between two probably and generally opposing groups whose rights and beliefs or protected characteristics are both protected, and they need to take some action so as to not be breaching the rights of either one or both of those groups, but they might have to know what the right action to take is. And the unfortunate thing to say is that it is really very factually specific and factually dependent. And we don't just say that because that means more people have to come to us for advice, but it really genuinely is one of those areas where we have a breakthrough case that comes through that it seems as though it's giving us a really direct answer. So, for example, we'll perhaps talk about in a bit more detail what constitutes a philosophical belief which is worthy of protection, and the four-starter case, four-starter in CGD Europe in 2021, the Employment Appeal Tribunal said that the gender critical views that four-starter had was a philosophical belief that was protected as a protected characteristic. So treating her in a certain way because of those views was or could be discrimination. But it's not quite perhaps as simple as that, as being, okay, so all gender critical beliefs are protected, because actually there are limits again to how far that takes us, and whether actually the manifestation of those beliefs is not protected because of the way in which they've been manifested, or the impact that perhaps it has on, in the employment law sphere, the impact it perhaps has on the business or on other employees. So it's not quite perhaps as straightforward as knowing where we stand and which beliefs are protected and what action an employer can take or ought not to take.
Yeah, because one of the things we're seeing very recently, I think, is the rise of more right-wing politics. And I think probably changing ideas of what constitutes sort of toxic views. Is there any agreement as to what toxic might be anymore? And where does the line? I mean, where does the line lie? And how do employers work out where that might be?
So, well, I'm not sure there ever has been agreement over what might constitute a toxic view, but I think it's probably right to say in this sphere that the views, beliefs, and expression of those in the workplace that an individual has, which is likely or which has the potential to impact on, to cause some form of damage, harm, upset to others in the workplace, is likely something we're going to be looking at or considering perhaps a toxic view, something which is going to lead, as we've said, to these sort of two opposing groups or viewpoints, which also seems to be that there's no middle ground where they'll be able to agree on some form of compromise. That's really the difficult situation that we're looking at. And as I sort of referred to, we've got four-starter dealing with the gender critical beliefs. And in terms of where employers draw the line, there's also the example of Thomas and Surrey Borders Partnership NHS Foundation Trust. That was EAT case of last year. So Mr. Thomas had English nationalist views, and the tribunal, the appeal tribunal, considered that nationalist views themselves, English nationalist views, may well be protected views, worthy of protection in society. But the important thing, I think, is, and this is for employers to note, is that it's very important at the outset to identify what is the belief, the opinion, which is said to be protected. Was it just English nationalist views? Or in this case, for Thomas, it wasn't just that, it went beyond that, and it also included his giving public statements agreeing with the forcible removal of all Muslims from the UK. And so because of that extension of what his belief was, that it was no longer capable of amounting to, in the appeal tribunal's decision, capable of amounting to a protected belief. It put his views in direct conflict with the fundamental rights of others. It prevented it from being a protected belief. And so it's quite difficult really still for an employer to look at the decision in Fullstarter against the decision in Thomas and to understand when a protected, firstly, what the protected belief is and when it might be protected, and at what point it extends further than the original part of the belief that might be protected into something that actually does promote intolerance, but in particular the actual exclusion of entire other groups, religious groups or other groups from society, at which point it's likely not to be a protected belief.
Yeah. Is there a danger that employers essentially end up getting co-opted into political activism, or taking a stance on a particular topic, or simply importing that kind of polarized and intractable debate into the workplace? That you end up, because everybody's entitled to a voice or a position on something, you end up with, as we've said, that sort of hopelessly polarized position between two or more groups in the workplace. I can't imagine that sort of adds up to a particularly great place to work. I mean, is that a danger?
No, and that's what it's really quite important an employer does its best not to do. It's very important. Obviously, what an employer wants to do is, yes, have a better place to work. But in terms of the advice that we're giving is to reduce the risk of claims because of that environment in which their employees, workers are working. The reality is, where you've got these opposing groups, whatever the views are, there is going to be fallout. I think the best thing an employer can do is be fully informed of what or the circumstances in which something may or may not be protected, and perhaps where those limits might be drawn, and to ensure that its employees are informed as well. Obviously, every scenario, as I say, is fact specific, and those two cases that we've just looked at sort of highlight that. But a very important, perhaps practical step an employer can take is to not act on the stereotype relating to any particular belief. It might be one which is obviously offensive to a group of others in the workplace and still be capable of protection. So it's important to tread very carefully. They'll want to bear in mind, considering exactly, as I say, what the belief is that may be protected, and consider whether any action that they're taking because of that might be allowed or not allowed because that belief itself is protected. And if one of the arguments is that there's some widespread or some serious harm or damage to the business or to particular individuals in the business because of those beliefs or because of the expression of those beliefs, it's important a company collects really objective and very solid evidence of that, because it's for the employer to show that they are taking proportionate action, if they are taking action in relation to something which comes from or which is a protected belief. So that will include looking at whether there's alternatives to the action that's going to be taken, less serious steps. So, for example, rather than dismissal, a further training session, a warning about what's considered acceptable, mediation, things like that, and looking at whether there are lesser steps that can be taken before taking any more serious steps.
And what about the flip side, that one of the difficulties with protecting people who speak up, of course, is that you also have a potentially different group of people who feel silenced and scared to speak up. And there are a number of recent examples, particularly in sort of gender critical debates about things like female athletes feeling unable to speak up in relation to issues which impact them. Is there an issue with that in terms of protecting those who might feel unable to speak up, or encouraging them to speak up? How do employers go about thinking about their entitlements and rights in the workplace?
Is there an issue? In a way, perhaps not. People have still held those views, beliefs, but perhaps avoided saying things in a particular context. So at or related to work, for example, which they may receive backlash for, which they may or because they may feel that that might insult or harass other groups. I think it perhaps comes from a lack of clarity in what is protected, what is permitted, like you say. But also, there's people speaking up or now in relation to the issue or the topic of trans inclusion in sport. Again, perhaps that is because people are scared to give their opinion on it because of backlash, or perhaps it's also because they now feel enabled to speak up, to follow that opinion of a lot that has come out since the Supreme Court decision. I think, as you're going to come on to, I think in a bit though as well, silence isn't always a bad thing. It can provide protection on both sides, and it's important that we recognise that as well.
Yeah. Because, I mean, that's the other thing that has been on the agenda both in the UK and Jersey recently is non-disclosure agreements, NDAs, and their use, and proposals in the UK and in Jersey for banning them. What a ban actually looks like, we don't know yet. We're still looking at some of the proposals, but one of the things I've been quite struck with in terms of the debate is the number of advisors who act for individuals who've made it quite plain that NDAs actually have a place, that many people who've been victims of harassment in one way or another actually would prefer an NDA to be in place, that actually silence again has its place. Where do you stand on that? Where should we end up on those debates?
I feel they definitely have a place when used correctly. The non-disclosure part of a much broader, much wider settlement agreement that we generally see in employment settlements, it both encourages employers to enter into settlement of employment tribunal claims or potential claims, which is broadly, in my view, in the employee's favour, rather than entering into employment tribunal proceedings which are obviously long, obviously expensive, obviously difficult. It also allows the parties, including somebody who may have suffered, it allows them to draw a line under things for compensation which they consider adequate to do that and to move on from it. The other thing I think to note importantly is that NDAs already aren't legally permitted to stop individuals from disclosing evidence of criminal behaviour to the police. So various forms of sexual or racial harassment and other discriminatory behaviour, which amounts to a criminal offence, can already, even with having signed an NDA, can already be disclosed to the police. A settlement agreement can't stop an individual from whistleblowing to a relevant body, or from disclosing information where required to a relevant regulator. We see all of those things very regularly explicitly drawn out of settlement agreements now. And I think if what the individual wants is to speak out about abhorrent behaviour that they may have suffered in the workplace, they can still do that. They can do it in the employment tribunal by not accepting a settlement agreement. They can do it to the police. They can do it by whistleblowing to relevant bodies, by referring individuals to regulators. We have very low sort of cost consequences or cost risks in the employment tribunal in general. So if you've simply refused a settlement agreement which includes an NDA, you're not forced to sign the NDA. You can continue down all of those routes. And I think what's the alternative to an NDA? We'll have, I think it's likely we'll have fewer claims settling, more proceedings in the employment tribunal, and I'm not sure that really does benefit either party.
No, and it comes back to that component that it's really easy to sort of paint in primary colours with whistleblowing, with the protection of philosophical and religious belief, and in relation to NDAs. And the moment you sort of start prodding below the surface of this stuff, it's the complexities become very, very clear, and it's quite an interesting exercise. And going back to that employment law god for a day, if you're talking about writing employment law for small jurisdictions, I think I'm quite keen to sort of avoid as much complexity as possible while still doing justice to the parties. That's a particularly difficult trick to pull off, particularly when we're talking about small jurisdictions. So it'd be really interesting to see where England and Wales end up on NDAs, because I suspect Jersey will do something very similar. And I know that I think Ireland have got an approach which ends up very much in the position that England and Wales are talking about going to. So which seems to work quite well in that jurisdiction. So it'll be very interesting to see where England and Wales and subsequently Jersey end up. I mean,
watch this
space. I mean, the other area that we haven't touched on really is speech outside the workplace, because of course you look back at some of the recent examples, Gary Lineker being one, in terms of people's sort of private speech outside the workplace on Twitter, on social media. Should employers try to control what employees say on their social media accounts? I mean, is it any of their business? How do they go about doing that if they want to in the first place? Do employers have any business, trying to control what employees say?
There has to be some level of oversight in some situations. I don't think it's right to say that every employer ought to have oversight over what's said on people's personal workplace, personal social media websites or anything else of that nature without exception. That obviously can't be right. But there are various professions in particular where what is said in your social life or what is done in your own personal private life does have an impact on your professional life, on the individuals that you work with, that you work alongside. And I'm thinking of teachers, and one of the obvious cases in this area in employment is Higgs and Farmer School, and that did involve not a teacher but somebody that worked at a school and alongside children. She was dismissed for gross misconduct following a complaint from a parent about social media posts. So exactly this. It was it was gender critical views, and it specifically criticised the provision of sex education and the teaching of gender fluidity in schools. We knew from for starter already that the belief is protected. So the EAT went to appeal, was looking at whether the conduct manifesting that belief can be properly considered objectionable and separable from the belief. Because if that was the case, they said that the discrimination claim would fail. So if the school was taking action because of the way in which she had manifested the belief, not because of having the belief itself, then the discrimination claim would fail. The Court of Appeal then, as it went higher up, said the EAT had erred in its application of the analytical framework. It might or it might not be, again, not the most helpful in terms of looking forward and planning and knowing what we can and can't do or ought to do. But it said it might or might not be protected if the belief has been expressed in a certain way, which is if there's a particular something about the way that's been done that's objectionable. It's only lawful if the dismissal, so in this case the individual was dismissed, or if the detriment, if it's something short of dismissal, was an objectively justified response to the objectionable feature about what was done, the way in which the belief was manifested. Again, it's obviously highly fact specific. There's no checklist approach. That's what the Court of Appeal said. So if we look and compare that, for example, to in Higgs' case, the Court of Appeal said that the dismissal was disproportionate and it was unlawful, therefore. But that's because the social media posts in Higgs' case was that they weren't grossly or gratuitously offensive. That's what the Court of Appeal found. That was quite a high threshold. They were largely reposts, not her own words. There wasn't evidence that the reputation of the school itself was damaged. So she posted in her maiden name. There was no link back to the school on her social media post, website or page. And there was no evidence either that she'd ever carried those views or manifestation of those beliefs into the workplace, or that the children would be in any way affected. But it has to be right that there are certain circumstances in which, if those views do carry over into the workplace and may have a detrimental impact on the individuals being worked with, whether those are children, whether those are other individuals, that an employer is able to have some form of oversight. And I know from the professional regulation background as well and side of things, that the Teachers Regulation Authority, if Higgs was a teacher, would have oversight over certain actions taken, posts shared on social media in personal and private life, rather than just in the workplace specifically.
But if you go back to the school, a farmer's school, Randall and Trent College, you're asking a school to exercise what sounds like an incredibly sort of judicial function, going through a number of steps there that arguably is taking a number of courts quite a while to get to grips with. Is that sustainable to expect of employers to get that right?
I think we're seeing that it's really not very easy for schools or for other employers to get right. We are seeing that it's an incredibly difficult area to know what the right thing to do is, and that's because of how fact specific it is. It's perhaps a judicial function. Really, it is a question of law that lawyers are there to advise on, and I think that is the only approach that employers are able to take at the moment, in particular, because it's not sustainable to ask. It's not even possible at the moment, let alone looking forward, to ask employers to make those types of decisions about and to be right every time about what the appropriate action to take is, and about how to balance those views, and about what's proportionate and what's necessary. It is something that they can take sensible steps about. So the things I referred to earlier, not jumping the gun and sort of taking one side or the other about what's appropriate, recognising that even though there may be views expressed which are potentially harassing to other individuals in the workplace, they may also still be capable of protection. And so understanding that and being careful about what steps are taken so that there's an attempt to protect everybody, which obviously isn't always going to be possible. It just is one of those areas that I think it's. But then we've always asked employers to take legal decisions about what's reasonable. They've always been asked to look at the range of reasonable responses when deciding whether to dismiss somebody, or whether actually a reasonable employer might have taken an action less serious. And so it's just one of those things that comes with the territory of being an employer. It's just a much trickier one. Yeah.
And that's before we get to being able to sort of send messages to employees, individual employees, about what's acceptable, what's not acceptable in the workplace and outside the workplace. Because if we're saying this is a very complex area to get right in terms of decision making, what are you then telling employees? Is there a case for being sort of almost more conservative in your messaging, that trying to tell employees actually saying less on social media or in the workplace is probably a better idea? It's less likely to get you into trouble. Is that the message, or is it?
It is, but I think it's that message without trying to limit what people do say entirely. But because if it's quite easy to say that the best way to avoid insulting anybody is to not say anything, but then we're not protecting individuals' rights of freedom of expression, so we can't do that.
Yeah, and we're back to not having a speak up culture, and people staying silent in the workplace, which is kind of the door we came in, isn't it? So,
and all you're doing there is avoiding getting into trouble in relation to saying anything offensive, but not the employer getting into trouble in terms of restricting the protected sometimes views and manifestation of those views and expression of those views of its employees or other individuals. So I think in terms of what's said to employees about what they can and can't do, the best way, perhaps the only way forward really, is to be incredibly general because it is always so fact specific, and unfortunately that's not particularly helpful. But I think being any more specific than that is going to end up in just as much hot water as providing for very general advice.
And some of the best messaging I've seen, and I think we talked about the Australian broadcasting policy on social media use, which I think is quite famous for being brief but sort of unimpeachable, and the idea that you shouldn't damage the ABC's reputation for impartiality and independence, don't undermine your effectiveness at work, don't mix the professional and personal in ways likely to bring your employer into disrepute. don't imply our endorsement of your personal views, don't disclose confidential information, and try not to offend anybody. And beyond that, it's very difficult, I think, for employers to say too much at all, outside of the sort of standard policies on non-discrimination. It's very, very difficult then for employers to say much in that context. But I mean, it brings us back to, this is very complicated stuff. If you're looking at in our context in Jersey, if you're looking at which bits of England and Wales or UK employment law to import, it is very, very difficult to know how much complexity is worth the importing of that law, in terms of allowing employers to manage their workplaces effectively. So yeah, very, very interesting and very, very complex, but constantly evolving. But what would you change if you were employment law god for a day? What's one thing you'd change?
Just scrap it all and start again. No, no. I think what we have as a broad structure, it works well, and it's also the best we have. I wouldn't want to be implementing new law. That is. I didn't go into politics and to be in Parliament. I am here to try and interpret what has been already put in place, and I think that's where I best sit.
Fair enough. Well, I'd like to thank Louisa for coming to talk to us, for what was a really thought-provoking conversation. If you'd like to talk to Carey Olsen, or indeed Louisa, about any of the issues we've talked about today, or if you've got any ideas about topics we should cover in future, please do get in touch. Otherwise, we will leave it there. Thanks very much, Louisa.
Thank you for having me.
Thanks.